Hello, my name is Brant Hunt. My channel is Discerning What is True. I'm going to be reading from the book called Woe Unto You Lawyers by Fred Rodell, maybe chapter 10, that is, today. Um, so I hope that you will glean some wisdom from Mr. Rodell. I'm actually live on Facebook, also live on YouTube, and also on Odyssey. So let's get into the book here. Thank you for being here. And for those who have ears to hear, for those who have eyes to see. Touch the chapter 10, that is, a touch of social significance. There is a quote by Oliver Goldsmith here. Laws grind the poor and rich men rule the law. Pretty much sums it up, doesn't it? And I'm going to change this right quick here. In case it should not yet be perfectly apparent, it may be worth stating here and now that the purpose of this inquiry into the law and its mysterious ways has not been and is not what today would be called a social significant purpose. That is, it has not been to prove that the law, in terms of its results, oppresses the poor and favors the rich and is a tool of the big corporations and is almost always found on the side of wealth, Wall Street and the Republican Party, although both parties are involved now. Practically every crucial book on the law ever written attempts to prove just that, and there are hundreds of them. The trouble with them all is not by any means that they are not, for the most part, quite right. The trouble is that they get just that far and no further. Their authors, who are usually lawyers, have no basic quarrel with the law as a method, a science, a technique of running the world. They merely want to see it work for their side. See, they're not out to tear down the law. They're out to remodel it slightly so that it results suits them better. The purpose of this little inquiry has rather been to show that the whole pseudoscience of the law, regardless of the results, is a fraud. It's just as much a fraud when it sends Dick Whitney to jail as it is when it sends to jail a starving man who steals a loaf of bread. It is just as much of a fraud when it favors sharecroppers as when it favors coupon clippers. It's just as much of a fraud when it protects civil liberties as when it protects the profits of holding companies. It's just as much of a fraud when handed down by a liberal court as when handed down by a conservative court. It is a fraud, not because of its results, but because of its manner in which it purports to arrive at them. Yet no inquiry into the law could pretend to be complete without at least some slight consideration of the law's famous tautological boasts about equal justice for all. For the boast is a lie. The law not only can be bought, although usually not in so direct fashion as it was brought from ex-judge Manton, Manton, but most of the time it has to be bought. And since it has to be bought, the results tend to favor those who can afford to buy it. Moreover, the fact that the law is constantly for sale, and generally to the highest bidder, ties right into the fact that the law as a whole is a fraud. For the law could not be bought, and it would not favor those who can afford to buy it, in the vaulted principles on which it is fashion really were the ready keys to certainty and justice, which the lawyers claim them to be. It's because these principles are so many and so meaningless because they can be chosen and twisted and sorted out to support any result under the sun, that the law does not produce justice, which in itself implies equality of treatment for all. In considering how and why the law has to be bought, it might be well to remember once more that the law is not the laws, as most people think of the laws. It is true that legislators and members of legislators and members of Congress have been bought, or at least paid for, so that they would vote for or against proposal statutes which would affect the interests of those who did the paying. But this practice, though deplorable, is a minor phenomenon compared to the day in, day out purchase of the law. For the law is that body of abstract, amorous rules which supersede written statutes and even constitutions, and under which the lawyers and the lawyer-judges resolve all our problems, settle all our disputes, and run all our lives. It's well worth buying. How then is the law bought? How is it regularly turned to the account of those men and those companies who have money enough to pay what it costs? The law is bought. To put the answer be bluntly and briefly right at the start, by hiring the services and advice of a smartest lawyer, of the professional soothsayers who are most adept at manipulating the principles of which the law is made. It is bought by paying a premium in court and out of court to the 20th century medicine man who can best cast spells of legal language to protect and defend the personal and financial interests of those who would be hard to put to protect and defend with interests in terms of justice, undiluted by law. Now, most people, if they think at all about what money can do in the way of legal protection, they think exclusively about criminal law. They think about Leopold and Lowell being able to hire Clarence Darrow to keep them from the electric chair. They think about the Mitchells and the Insuls, the captains of industry who get caught doing strange things with other people, money, and who can then buy the services of the cleverest and yet most respectable members of the bar to save them from legal punishment. People contrast such going on with what happens daily to the ordinary murderers and ordinary thieves who can only afford to cut rate prices charged by poorer lawyers who have to have their lawyers supply them for free and third rate, just so that the outward appearance of the justice for all ceremony may be maintained. And most people realize there is something distinctly unfair about all this. There is, but it's only a very small part of the story. In the first part, criminal cases, although they take up most of the newspaper space devoted to the law, take up only a fraction of the time of the courts. The bulk of the business of the courts is given over to what the lawyers call civil suits, in which one person sues another person or one company sues another company, usually over some financial or business squabble. In these cases, just as in the criminal cases, and it is particularly noticeable when a corporation is on one side of the dispute and a lone individual on the other. The most money buys the best legal assistance. And the better your legal assistance, the better your choices or chances of ending up with the law in your favor. Far as cannot be repeated too often, the law is not by several long shots the certain and exact science at which it masquerades. If it were, even the richest corporation assistants would not throw its money away on the tremendous fees that the leading lawyers charge their clients. Any lawyer, or perhaps no lawyer at all, would do just about as well. But the corporations know, and the lawyers know, that a master manipulator of legal mumbo jumbo is a far more useful thing to have on your side in a lawsuit than all the certain and impartial justice in the world. True, in a great many legal disputes, there will seem to be more principles of law or more compelling in the abstract principles of law available to one side than to the other. But the other side will always have some principles left to play with. And just as in the game of bridge, so in the game of law, an expert player will beat a run-of-the-mill player 9 times out of 10, despite the fact that he may hold worse cards. Yet it is not only and not chiefly on the purchase of smart counsel to represent you in actual court cases that the law has to be bought. The law, although it oversees all human affairs, does not apply itself automatically to the settlement of human grievances. The man who thinks he is being cheated in a personal or business way, he thinks he is being deprived of his just rights, so clearly that it is even a violation of the legal system of far-fetched principles, must go to court to try to get any satisfaction at all from the law. And it costs money to go to courts. It costs money even before the bills for the lawyers' fees begin to come in. That is why most people never in all their lives become plaintiffs in a lawsuit. Farmers, factory workers, and housewives and unemployed people have their legal grievances, just as rich men and big corporations have their grievances. but they cannot afford to buy so much as a shot at the law. He's correct. Totally 100% correct. It's just amazing. You're taught this stuff in school, but in reality, you go to court and you find out really, you find out who the law is. That's what I said. Something I always say. Something they will throw somebody in jail for someone stealing some food. The guy is starving, and yet these other people get away with far, far more worse things. And guess what? They get out. They never even get in. So the law is crooked, you see. A man who is pretty sure the agreement he made is being broken when the financial company takes away his car or his radio because a couple of payments have been delayed cannot think of hiring a lawyer and going to court about it. It costs too much. A clerk at a big department store who thinks that some new government statute hits him in a unfair, perhaps illegal way would not dream of going to court about it. But the store would go in a minute if it felt cheated by some written law. A workman's wife who's desperately unhappy when her husband and has perfectly adequate grounds for divorce will not sue for one. Divorces like suits against the government and the legal efforts to get a fair deal in ordinary business arrangements, and like almost every kind of law case in the book, are the exclusive luxuries of those, and there are very few of them who have money enough to pay for the law. A several $1 million corporation recently complained in print about the terrible cost of carrying to and through the courts a protest against a ruling of the National Labor Relations Board. The point was well taken, yet it serves quite nicely to emphasize the elder helplessness of the ordinary man with agreements that he would like to expose to the law. The corporation at least could and did afford to pay the thousands of dollars necessary to get a legal hearing on the wrong that it thought had been done it. But what chance, for instance, would an employee or a customer or of the corporation have to air his complaint in court is he, though he has been unfairly and illegally treated by the U.S. government or, for that matter, by the corporation itself. The disadvantages of the corporation up against the U.S. government in a matter involving the law are as nothing compared to the advantages the corporation holds over every individual who works for it, buys from it, or invests in it, whatever the law is or might be concerned. Still, it is not in buying smart soothsayers to talk for you in court, not even buying your way into court in the first place, that the law is most commonly and most effectively sold and purchased. Most of the business that lawyers handle and live on is made up of matters that never get near a courtroom. Most of the business that lawyers handle and live on is made up of what is called legal advice, usually by financial matters. That is tendered. That is a price to those men and those companies that feel it will be worthwhile to get the law safely on their side before they embark on any money-making or money-saving deals of any kind. And legal advice amounts for that, for the most part. The casting spells of legal language over the wording of business documents so that the documents, if they ever should be dragged into court, will show that, regardless of where non-legal justice may seem to be, or should lie, I should say, the law is pretty clear on the side that bought the legal advice. To take a very simple example, suppose a man should set up a parking lot and hand out plain numbered tickets, like the checks you get when you check your hat in a restaurant, to everyone who parks his car in the lot. Suppose a woman should park her car and leave her fur coat in the back seat, and should come back to find that the fur coat has been gone. Suppose, moreover, that she should be mad enough and wealthy enough to sue the parking lot owner for the loss of her coat. The chances are strong that the law, after tossing an abstract principle around in profusion, might hold him responsible for the loss and make him pay her the value of the coat. But it's not really his problem, you see. They're not dealing with a real person who's the thief at that way, because this is how they deal with it, you see. Yet most people who lose articles out of cars left in parking lots have scarcely a chairman's chance of getting a cent out of the lot owners, you see. Most parking lots are owned by people or companies with money enough to buy legal advice beforehand. And so most parking checks are not plain pieces of cardboard with numbers on them. They have numbers on them, all right, but on the back of the check or at the bottom of the print in small type, the owner of the car covenants that the bailee will not be held liable or responsible for the loss, theft, or damages or articles, etc., or words in that effect. Courtesy of the legal advice, the law has been carefully placed on one side of the potential lawsuit without so much as the knowledge of one of the parties to the contact. That is, has been placed there just in case, you see. It is the same on a much larger and more complicated scale with leases. It is the same with mortgages. It is the same with insurance policy. It is the same with stock issues and bond issues and all the other legal devices by which business concerns of all kinds and shapes earn, beg, borrow, or steal other people's money and use for themselves. There's always that big block of small type something running to several pages, which the ordinary purchaser or tenant or borrower or lender or investor does not bother to read and probably could not understand it if he did read it. That block of small type is put there as the advice of lawyers. What it means is that if any trouble should arise over the little business arrangement, the ordinary purchaser or tenant or borrower or lender or investor is almost surely going to lose if he should be fool enough to carry his complaint to the court. The other fellow, the company of the individual with money enough to afford it, has been canny enough to buy the law in advance. Of course, if all happens in the world of finance and industry that both sides of a business deal are able to hire legal advice right from the start, that is the lawyer's heyday. Counsel for each side, without so much as a minor lawsuit anywhere in prospect of the time, would fight to outdo each other in the clever manipulation of legal language and the careful building of legal fences so that their client's interests may later be defended, if necessary, in strict accordance with principles of law. Yet, unless one sets up lawyers is much smarter than the other set of lawyers, both sides might just as well dispense with their lawyer altogether, so far as driving a reasonable and profitable and fair business bargain is concerned. The hitch is that as soon as one side resorts to legal advice, the other side has to use it too in self-defense. Thus, everybody loses except the lawyers, you see, who go merely on selling the law. But since most business transactions involving a big fellow and a little fellow, a company, for instance, that can afford legal advice and customers who can't, the law is usually weighed to one side from the very beginning. It is weighed by lining up beforehand. It is in written terms of the transaction, the legal language that will fit right into legal principles in any lawsuit that might later arise out of the transaction. And it is this fashion, I should say, even more than by the hiring of smart word jugglers to represent you in court or by the purchase of a court hearing. To begin with that, the law is regularly bought and therefore regularly tends to favor those with money enough to buy it. That is why the center of the nation's law business is in New York City, and why the bulk of the nation's influential, profitable law practices is carried on in the Wall Street law factories, you see. People and companies in other parts of the country have their legal grievances and disputes and their court squabbles, and they have them in much greater proportion than the proportion of a nation's law business that is carried on outside of New York. But the richest people and the biggest companies make almost all their financial arrangements and their important business deals in New York. And financial arrangements and important business deals, even more than actual legal disputes, are what the lawyers thrive on. Most New York lawyers spent, you can call them liars too, spent most of their time working out legal advice for the business titans that make their financial headquarters in the city. It may be advice about how to word a series of mortgages or conditional sale contracts or leases or stock certificates so that the little fellows on the other side of the deals will have little or no chance for legal redress. If they should later feel themselves cheated, it may be advice about an intercorporate transaction where the sole real usefulness of the advice will be to counter any tricks of legal language that the other side, also advised by high-paid lawyers, might try to pull. It may be advice about how to get around a bothersome government regulation that still keeps on good terms with the law, which of course is more almightier than a government regulation. Advice that thousands of smaller companies or less wealthy people would love to have too. if only they could afford it. It may be advice about how to make use of legal language so as to get out of paying taxes. And when J.P. Morgan, for all his yacht and his grouse shooting and perfectly legal, avoided the federal income tax for a couple of years, while hundreds of thousands of $1,500 a year men had to chip in to the U.S. Treasury. In any case, it will be advised which has a dollars and cents value to the person and the companies that buy it, somewhat greater than the stiff prices the lawyers charge for it. And the direct or indirect losers in the whole affair will be the companies and people by the millions who cannot afford this to buy. The law, that is, there's more striking parody of the law's boast that it represents equal justice for all than in the work of those top men of the legal trade who cluster and prosper in New York City. Moreover, most good lawyers go to New York before they die. They go to New York because that is where they can make the most money out of their knack of tossing around legal principles and legal language. As a matter of fact, herds of them are coaxed straight to New York from the law schools every year. And thus, incidentally, the profession gets in another telling blow for perpetually of the legal legend. Whatever slight doubts about the reasonableness, practicability, and majestic of the legal process may have been left in the smart youngster's head after 3 years of rigid drilling in the sacredness of abstract concepts, quickly evacuate an atmosphere where the law is acknowledged king, and the king and his pet curators are so handsomely rewarded. Here, too, is the kernel of another reason why the law is kindled to the rich than the poor. Not only are the most promising young hocus pocus artists immediately lured to the service of those who pay them the highest wages for the magic, but out of this group spring eventually and almost automatically most of the acknowledging leaders of the profession. For as in other trades and professions, earning capacity is universal and blindly accepted as the hallmarks of a real ability. For example, Benjamin Franklin once paid tribute to the fact when he suggested that the lawyers appoint the judges on the grounds that they would always pick the ablest of their clan so that they might most profitably divide each new judge practice among themselves. And despite the fact that Franklin's scheme had never been put to direct test, it is out of the acknowledged leaders of the profession who are acknowledged to be leaders because they make so much money that most judges are chosen. Now, when a lawyer becomes a judge, he no longer has a direct financial incentive to manipulate. The law is in favor of the rich people and the big corporations, you see. But he will usually have spent most of his professional life before he became a judge doing just that. What is more, he will not have admitted, even to himself, that he was doing anything other than apply a exact and impartial science to the orderly management of men's affairs. In elderly protection of his own self-esteem, he will perforce have swallowed most of the legal legend whole, and consequently he will have hardened into a habit of mind whereby justice and the legal principles he is used to using are just about synonymous. When he becomes a judge, he cannot easily shake off this set slang towards the law. The principles and concepts the concepts he once flung about and fought for, mouthed now by other lawyers trying cases before him, will still have a familiar and authoritarian ring. Such phrases as freedom of contract, caveat emptor, and the sanctity of written, that is, by lawyers' agreements, and the privation of property without due process, along with all the minor and equal vague abstractions with which lawyers customarily defend in and out of court the interests of the wealthy clients, will strike their eyes and ears of the judge as good sound legal advice. By contrast, the phrases and principles of law customarily used to argue against such interests will seem less familiar, less organized, less compelling. Conditioned by his own past habits of legal speech and thought, the judge will unconsciously lean in laying down the law towards the side that he talks his old brand of legal dialect, which means that he will lean towards the side where the money lies, and the law will lean with him. There's one more important reason why the law regularly tends to favor the rich, the conservatives, the people, and the companies with plenty of money and property who not unnaturally want to keep all their money and property and keep on getting more of it in the same old ways. This reason is inherent in the very nature of the law itself. The law, you may remember, purports to be a great body of changeless abstract truths. Times change and ways of living change, and the fact of human affairs change, but the principle of the law remains unmoved and steadfast. In short, the law, by its own definition, is a stand pat science. And of course, it is the wealthy and well-to-do who are always stand patties. You see, for the patties, they're poor, and the not so well-to-do are the progressives and the radicals. The money groups are, for most part, very nicely satisfied with the old arrangement of things, justice or no justice. In the original Christian sense of the word, they don't want to see the rules shifted in the game of getting ahead in the world. And they find in the law a philosophical and less obvious selfish defense of their resistance to change. They also find in the law something more solid and more useful than a philosophical defense of conservation. For the law, mysteriously brought to earth by lawyers and judges, does control all earthly affairs, and in being transmuted from abstract principles into specific decisions about human disputes and problems, it retains its reactionary flavor. New rules of the game, new arrangements in men's activities, new consideration of what is practical and what is fair, fit less smoothly and less snugly into the law scheme of principles than to do the old considerations, the old arrangements, the old rules, you see. That is one reason why so much progressive legislation, meaning laws that try to change the rules to favor the poor at the expense of the rich, is either damned entirely or interpreted into ineffectiveness by the courts. The novel arrangement just don't slice easily into the old unchangeable principles of law. For instance, the newfounded or newfang notion that a worker ought to be paid a living wage didn't stand a chance when it first came up against the age-old law encrusted right of the corporation to pay its workers as little as it pleased. There might have been a law about it, but the law has never heard of such a thing. Similarly, the idea that a homeless man might be legally justified in breaking into an empty house to sleep, an ideal that could certainly be argued from the standpoint of pure, unadulterated justice, would be laughed out in court today. As with the idea that a bond salesman whose glib assurances had led an old lady to invest her savings could be sued by the old lady for what she lost when the bonds later became worthless. But the judges will not, if they can help it, go to the trouble of reshuffling the law huge deck of abstract principles in order to reach and rationalize a radical different set of practical results. Only rarely and reluctantly would they turn the stream of legal logic in a reality new direction. Only rarely and reluctantly will they tolerate in the law name far-reaching or basic changes in the matter of adjustment of human problems. Thus, not only the law, but the general trend of legal decisions remains the same, and by remaining the same in favor of the interests of those who stand to benefit by a retention of the old rules. It favors the conservatives, it favors the rich. Yet the social significant books about the inequalities and injustice of the law and actions are right as far as they go. And incidentally, a prominent member of the bar recently summed up a large part of their theme in a phrase when he described the idea of client, the lawyer's dream, as a rich man who is scared to death. But still, it is the fact that the law as a whole is a fraud that lies behind all the inequalities and all the injustices. It makes it worthwhile for those with money enough to afford it to buy the court services and the pre-court advice of those mumble-jumble chatters and scribblers who can best wring desired results out of the legal language and legal principles. It makes it worthwhile for those with money enough to afford it to buy their way into court if the results they want wrung out of the law cannot be otherwise attained. It is responsible for the myopic inability of most judges to see beyond the one-sided principles they used to use when their own services were for sale to the highest bidder. It is responsible for the inherited inertia, the congenital conservationists, or I should say, of the law in action. Or if the law were really the exact and impartial science it purports to be, instead of being an uncertain and impractical abracadabra devoted to the solemn manipulation of a lot of silly abstractions, none of these bases of inequality and injustice would or could exist. The law indeed is a menace when it works so as to prevent or pervert its own boast of equal justice for all, when it favors the rich and oppresses the poor, when it results in the or in the particular seem to be plain denials of ordinary non-legal impartiality and fairness. The point is that even when the law works, as it sometimes does, so as to produce fair and impartial and practical results, it is nothing but an unnecessary and expensive nuisance. Those results might have been achieved much more simply and easily and painless without recourse to the metaphysical nonsense of the law. And it is this point which the social significant boys invariably miss. The social significant plot has grown stale in the telling. It always revolves around the conventional triangle of the rich, the poor, and the law. And the villain always walks off with Lady Law in its hand, which is supposed to show that she is a villain too, whereas actually she's only an empty-headed fool who neither knows nor could be taught any better. So that is the conclusion of chapter 10 today with Fred Rodell's book entitled Woe Unto You Lawyers. And so we're going to conclude that today, and I appreciate you being here. Yes, good to see you, Nate Maxwell. Thank you. Do you have an email or a website? No, I do not give those out. I don't have a website. Other avenues of contact. Thanks for covering these legal topics. Good work. I'm just reading from Fred Rodell's book, a book that basically most people can't even get. It's Woe Unto You Lawyers. You can, if you want to find that book, Nate, you could ask for going to the library and ask for what I call interlibrary loan, and you can get that book as long as you have a card with that. You can get that book. In other words, you can get that book for you to read. My suggestions also, if you get a chance, is to look into anything that's written by Eustace Mullins, which I've also have shared a couple of his books already. Eustace Mullins is also a man who actually tried to defend himself in court and basically never stand a chance where he was at. The law and the judges are in fact crooked, and it's very clear that most people don't get fairness at all. But I appreciate you being here and listening. Some of the things I suggest, maybe one day this is going to happen when everything completely fails. There's a possibility, if there's some people who, that's why I'm reading these books, that to give knowledge to others so that they can glean from that and use it and then share it with others. Because I feel like I'm basically just spreading a seed to someone who basically has ears to hear. And my hope is that, as I've displayed another idea that I've talked about, that, the banks themselves are a crooked organization also. And the only way to actually deal with this is actually start your own local bank with among yourselves. This is part of what I call bartering, but it also can be something of a bank. There is some good information from a gentleman called Patrick Devine. It's Patrick Devine, Devine. Look it up on YouTube, and there are literally hundreds of videos this gentleman did back in 2014 and 13 until he passed, I think, in 2015. And there's quite a bit of knowledge there to deal with that. There is also, I'm trying to think his name now. He recently passed away last year, unfortunately. These are older men who understood the money system also. That's what this is all about. I think the YouTube channel is called Patriots and Robots. It might be Robots and Patriots. One or the other way. And the other guy is, I know his name. It's not coming to me though. And there are people who have been successful at this. Yeah, basically, yes. I would say decentralize and diversify. Yeah, because you want to be in the private part. That's another thing. It's a public and private. When you go into with your legal name that is with all caps, you're in the public. And so that means you're able to practice in the public. That is, you're able to have, a driver's license or all these type of things. So you're a part of the system. In fact, um, you are the credit for this country. You are you're considered the collateral, but the reason why you're collateral is because you are the credit. That's how this country survives, and that's why how the country grew in first reality was to get other people coming here to become um, the move here, and then became creditors because money is based upon creditors, and they create money. And you know as well as I know, the real stuff is the gold and silver, but we are the collateral, and yet we are also the creditors of this country. If you look into reading, I know his name, I know it. There's another guy, I can think of his now. Let's see. I've done some videos about these guys. Actually, you can search my channel here, and I've done some videos what I call looking live under YouTube, or either to look into um, Odyssey, and I've done many videos on all this. Um, and there's a guy named Peter. His name was PJ, and his last name was Polinsky. He has some videos of you call yourself a secure party creditor, and that's what we are. We are the secure party creditor. That's all to do with you being the creditor. You are the creditor of your own. You see, and so this guy has done this recently. I think his videos are on the same wells. They're actually on the same website called Patriots and Robots, or Robots and Patriots. Either way, he talks about all that, and he is. Our Social Security is our trust. So we're not the trustees. The trustees are the state, but they've switched it. They've completely changed it around, um, to the point that simply is we're seen as the trustees, and that's baloney. That's a lie. Uh, but no one knows this or unaware of what's going on in the courtrooms too. But you're not the trustee. You are the beneficiary of the trust, and your trust is the Social Security account. You see, that's why you have this. That is the credit, so to speak, if you understand what I'm talking about, of the country. Once the country declared bankruptcy, the country's declared bankruptcy many times. It's been and in fact, the England gave the United States a 7-year type of deal and said after the war, which meant that the United States, as far as I know, if you have to pay the war debts, it means that simply you did not win the war between the Brits. Okay, so when they were given 7 years to pay that debt, which I think was $18 million, if I recall correctly, and with that, they couldn't do it, and so they came back to them, that is, and said, okay, we'll renegotiate, in fact, and we'll give you 70 years, that is 7 times 10, meaning 70 years, to quote unquote pay it off then. So that was in 1789, and then basically in 1859, it was 70 years up. And what took place, though, was to do with the South said, uh, basically the jig came up and says you're going to have to start paying this. You're going to have to pay it. And the South says, no, we're not paying it. We don't want anything to do with this. It's not our debt. You see, and so they left. Okay, so that forced the hand of Lincoln in some ways. Look, I've got to get the Union back together in order to do this. But they reneged on that particular failure. In other words, they didn't pay that debt off in 1859 or 60. And then what occurred was the Civil War, or the war between the states. And then what transpired another 70 years is 1929 with the Great Depression. And so it's been this whole deal that the United States has failed to pay. But what's happened simply is that England has taken over, Britain has taken over certain key things as collateral. Okay. And so in 1929, and then that takes place, you have Hoover, who's in office, who says, no, I'm not going to do this. But when Franklin Roosevelt runs, he says, yeah, I'm willing to do whatever it takes to to solve this problem. When in reality, he's not. So he's not able to solve the problem. And so what happens simply is they choose to create paper money that is debt money. And so it being debts, it's a note. It's a note, N-O-T-E, which is debt cannot pay debt. There's no way. Because before this was gold and silver, but that was eliminated. And you have to read, look in some of the videos I've done on Woodrow Wilson and how this all took place in many ways. One was simply is the protection of this country industry was to do with import taxes, which was where most of the money the federal government got in order to operate at that time. It wasn't through taxes until he started that, which we call the gradual income tax, which is unconstitutional. It's very clear. But that doesn't matter. The court does what it wants to do. But back to what I'm saying, back to Roosevelt's time, is the whole issue is that we instead of being able to afford to pay, they rob the people of the that could be called kangaroo courts. Unfortunately, people still have confidence in them. Once the confidence is gone, it's over, and they know it. In fact, if you listen to something that Biden said, he mentioned the word confidence in the system, confidence in the system. But if people lose confidence in the system, the whole system's going to fall. And it has to fall anyway. It's a rouge, you see. So back to the deal with Roosevelt was that they created the birth certificate, which was your all caps name. It was your part lying into your such and such, which they started that before this, okay? And then what happened was to do with what I would call, he decided, okay, so there's no silver and gold to pay for it. So where does it go at? Well, it goes into your trust. It goes in your Social Security account. And if you've noticed that almost all of the numbers you have, Nate, is that they're all 9-digit numbers. Your Social Security number is 9 digits. Your bank account is 9 digits. Your bank account number is 9 digits. Your street address, your zip code is 9 digits. I have a passport, and your passport is 9 digits. So it all connects, if you follow what I'm saying. And like I say, when I say zip code, yeah, you have 5 digits, but you have this what they call a 4-digit number afterwards. Well, that is your ID number, or that's your address. They're putting it as 4 digits, you see, based upon all that, you see. So, but I was trying to think. The other guy is Gene Keating, Jean Keating, Keating. He's well worth listening to. He's a brilliant man. Unfortunately, he passed away. He was actually doing classes for his students. I think he was reasonable. I think it was $25. I don't know if that's just for one class or if there's a whole core of classes. And P.J. Polinsky is the one who was his, I think it stands for Peter Joseph, was his quote unquote, his being taught, and he picked up the ball. Unfortunately, he's done his thing, such and such, and he has videos on there. He talks about secure party creditor. He talks about that immensely. You can look and listen to him and try to figure this whole thing out. But what they did simply is, and this is the other thing that takes place, most people are unaware, you can actually collect from your parents' Social Security trust And that's something I'm working through. All this trying to develop and understand. It's a lot. It's not something you just pick up the ball with. Um, you have 10 years to get that money out of that account also. You're worth millions and millions and millions of dollars. You're used as a collateral in order for the country to buy the things you are. You're the security of the country also. So, federal versus the Confederation, Indian nations and treaties, contracts, charters, and land. Yeah, I don't say I agree with what the South did, even though I am a Southerner, because I believe they actually wanted to divide the country in two parts. If you understand that the South was going to be, there were French troops actually in Mexico, and their whole idea was simply if the things kept going the way they were, the North would have been a British colony again, and then quote unquote the South would become a French colony. You see, that's what I understand. But there are many players playing in that position to get the South riled up to fight in the war. And actually, another thing that's going on there, under tying that, is to do with what I would call, we've been in martial law ever since. In fact, Lincoln goes and states this position about who he is by saying he's commander in chief. Okay, but that's not true. But every president ever since then states he's the commander in chief, which it never, that's why you have the flag with the yellow fringe upon it. It's because we're in martial law. They've never come out of that, you see. And so back in 1929, that failed. Roosevelt, such and such, brought all these programs in, such and such. So they decided to hide their trust money or whatever is owed to you in your Social Security. But it's not like your standard Social Security when you get 65. You actually can get it if you're smart enough at 18 years old and understanding that. Okay, but who's at 18 years old smart enough to do that? I don't know of any 18-year-old that would be able to pick up the ball because they're all caught up in all kinds of other stuff, you see. So the next 70 years was under the Clinton administration. So 1929, 70 years later, it's 1999. And 1999, is what I understand, was the mergers of the two banks, the investment banks, which were kept separate between what I call regular banks. And so what happened simply is they merged them together. And that's why we have such a serious problem in a lot of ways, far worse now with banks because they're brought together. People don't understand that. And so now they're operating on both sides of the fence, so to speak. And very few people understand this. And, that's another 70 years since 1999. So where are we seeing all these major issues just recently, again, with the banks, to do with what I would call, the dot-com failure. The also 2008 the mortgages deal, which in reality was simply is the banks were already in financial mess, so they sold those mortgages to foreign bankers to bail themselves out. And now what we're looking at is what's happened over the weekend, which has been coming. It's been coming ever since. They haven't solved the problem. Never have. It allows what I call bankers to waste money, throw it away on. Basically, it's just betting on some things. You see, it's like it's on a horse race. It's like betting on a horse race, and that's what a lot of it is to do. Even with the word, what is it called? Derivatives. Derivatives are just simply bets in some ways, and they bet each other that this is going to happen. You see, yes, the gold tassel. Yeah, right, correct. Well, we also, if you look at there's symbols all around. Another one is simply the fascist symbol with the axe. If you look at the Senate building, inside the building, you'll see the axe with the straw, whatever you want to call it. That is a symbol of fascism. So they're showing these things if people are aware of it. But I would suggest simply security party creditor. I think he does like This guy does, PJ does like 12 or 15 videos. He's out. As far as I know, he's out of the system. I mean, he's benefiting himself, and he started whatever he's doing, and he's no longer, he's benefited all this from that, you see. I know there's a lot to take in. There's another guy you can look into, talks about a lot of this in a more easier way, is John Robinson. He has like 8 or 10 books that deals with this. And there's some good books that he points out, and especially with what I call the triangle. He gives an illustration of that. The state itself is supposed to be the trustees. They're supposed to manage your trust. That's what they're supposed to do. All right. And unfortunately, they're saying you're the trustee, and that's why they're charging you such and such, when it actually is completely opposite. So when you get a bill from your power company or whatever, they're sending you a statement. But what they're saying is simply, we've already taken that money out of your account, out of your trust. But we've never been told that, you see. And it's in all caps, which is, that's where our trust is located at. And so this is how it's enormously a lot of stuff. And it's even more than what I'm just sharing with you. It's far more of that. But I appreciate your comments, Nate, and I appreciate you being here. Thank you for your support, and thank you for sharing what you know. Yes, federal versus confederation. Well, the confederation was one thing I would say simply was to eliminate the federalization of the thing. And we know simply in the past that the United States of America was the U was not capitalized. It was underscore. The meaning is simply as the states were capitalized, meaning they were superior. And that all changed in 1871 with the compact, or the I guess they call it compact, or the Treaty of District of Columbia. And that's where, and basically, you can even look at it this way, Nate, is that DC is where the United States of America is. That's where all your information is, so to speak, with your all caps, you see. That has become the United States, the capital U in the United States. The rest is not, because there's two entities going on here. One is simply that most people no longer worry, don't understand, don't see it, but there are symbols, different things that have happened to show that there is two, quote unquote, two countries or two places, entities that are operating side by side, if you understand. But anyway, thank you. You have a good day, all of you, and thank you for paying attention, and share with others this important and vital information. And again, this was Fred Rodell, Woe Unto You Lawyers, Chapter 10. All right.